just for good measure, they'd cut them loose and say, well, that case didn't even belong in here. Right? Showing up the other guys. That's if you weren't a common enemy. Now, if you were an enemy to both, if nobody liked you, well, that didn't work. Okay? But habeas corpus is the only known right in the history of law to have grown stronger with time. All others, the government slowly encroaches, but that one grew stronger. Why? Because it had nothing to do with rights. It had to do with turf protection on the part of bureaucrats. Okay? So, that's what habeas corpus really is. I think it's habeas corpus ad subjiciendum, something like that. Okay? That's the full name. But habeas corpus is turf protection. Now, how does that apply in America? Because what they did, the two most common battling courts were law and equity. So, in the United States, they combined them. Now the same judge is both a law judge and an equity judge. He was both a judge and a chancellor, because that's the proper title for an equity judge. He's a chancellor. So whether he's a judge, meaning a law judge, or he's a chancellor, meaning an equity judge, made no difference at this point. It's the same guy. As a result, 99.9% of all habeas corpus applications fail. Okay? But here's how it works with us. Once you go into common law, remember, the common law is still good here in the United States. Okay? Why? Because it's recognized by the Constitution. About 3-4 different places in the U.S. Constitution. When it uses the word law in the Constitution, they mean common law. Okay? So, there is an ancient rule of law that says that the king, the sovereign, is always subject to his own court. That's why you have a court of claims. You see, the king declares the law, and he says, okay, he decrees it. This is what the law is. But the king cannot break the law, because if he does something contrary to his own law, all that means is he changed the law. So how are you going to enforce the law against the king? You can't. So what you do, they acknowledged in England, and we inherited in the United States, that sometimes the king has a moral obligation. Maybe not a legal obligation, but he has a moral obligation. If an action by the king caused harm, even though he's not legally liable, he's morally liable. So they set up the court of claims, and that's the purpose of the court of claims. You go to the court of claims, you say, hey, king, come on, pay for what you did. Okay, new tape. Time out to flip.
Can you show us the document that launches the court of record? The number 2 document that shows the writing.
Line 2, you mean? Yeah. Paragraph 2 of that lawsuit? Yeah, sure. Sure, we go to the example. Okay. Yeah. All right, we rolling again? Okay, so the question is, how do you activate the court of record? Well, you do it in your action. Okay, so we'll go down here to the action. First amended action. Okay, and here it is, paragraph 2. Can you see it on the screen? William Jones is one of the people of California, and in this court of record complains. That's it. That's it. That's activated. You are the plaintiff, and as the plaintiff, you have a right to choose your forum. I choose the forum specified in the California Constitution. All courts are courts of record. And remember, I own those courts as one of the people. Right? See, if I own the government and the government owns the citizens, and I'm not a citizen, I'm one of the people, and I do not yield my sovereignty to the agencies which serve me, so I go into that court. That court's a court of record, and what's the definition of a court? It's a person and suit of the sovereign. Okay? That's in there somewhere, so you'll find it. But So combine that all together, and the person suited the sovereign. And I said it's a court of record, yes.
You did an earlier sheet that just said, this is a court of record all along.
Oh, that? Okay, sure, we'll go back to that. Gotcha. The definitions.
No, all along, this is a court of record. Right on that.
Yep, here we go. I think I know what you're talking about. Right here, court of record. There it is. This thing?
It's the case that came before the last one you showed. Says this is a court of record.
You lost me. I talk a lot, but I forget what I say.
Just before the last one you showed, then just before that.
Yeah, well, my memory is erased. I have a destructive readout on my memory. So. Okay. Well, I'm sorry I can't fulfill that request. However, it's on the film. So, but what is the question relating to court of record? What is it that you really were digging for?
Not that. It's the way you presented it to the court. The way you presented it to the magistrate.
Right up there, number 2 is what he presented.
Well, in the presentation to the magistrate is your original filing. That's what I showed you. That was the amended action. Yeah. The first amended action, which normally would be your action, but if you're doing a counterclaim, you would say a counterclaim, but you, right there at the first paragraph, you say you're one of the people, and this is a court of record. That's it, does it. You decreed the law because you're one of the people. And you're sovereign, so you can decree that sovereignty. Okay? So, going back to this other here, the habeas corpus. So in the habeas corpus, you see, you as a sovereign are subject to your own court. And there have been cases, like there was this one king, he was presented with a problem. The chief judge said to him, if somebody who was of one of the nobility, and he didn't want to name any names, but he said if somebody were doing this and he was cheating on his noblewoman in these conditions, what would be the penalty? And the king said, well, with that, it would have to be death. Well, it turned out he was talking about the king, and so the court executed him. Be careful who you appoint in your court. Okay? So, I make it clear that this is a court of record. That means no authority for the judge to make any decisions. He's a magistrate. He cannot make any decisions unless I permit him, unless I certify it. He wants something, he looks to me, I say, sure. Okay. Looks to the attorney, he says, sure. But I've already explained the difference. Okay? So, habeas corpus, that's what that is. Now, common law. What is the common law? You've all heard that it's custom and usage, right? But where do you point? How do you put some muscle behind that? Right? You say you want to run your court according to the common law. What is that common law? Now, you know how bureaucrats are. They like things in writing. They can't handle concepts for some reason. If you don't show it into writing, it doesn't mean beans to them. Well, I'm going to show you where the beans are. Okay? Confirmatio Cartarum. Magna Carta, basically the noblemen got tired of the king conducting his wars and forcing them into service and taking their wealth, to pay for the wars. So one day they cornered King John on the River Thames. And they presented this little document called the Magna Carta, and they said, sign it or we'll cut your head off. And so he signed it. Now, when he signed it, he had absolutely no intent of keeping his word, but they kind of had the upper hand. You remember, this is in the days when each nobleman had his own army, his own military. The king would borrow the military from the nobleman to conduct his wars. And also the Pope was kind of in charge there too, and the Pope later blessed it and said, yeah, the Magna Carta is good. But the Pope really didn't intend to keep the word either. and they were just going to wait for a more opportune time when they built their political strength and they'd straighten this situation out. Well, you know, I guess God works in mysterious ways.
That's not true. The Pope is the author of it. I read it.
Well, fine, he authored. I just said they presented it. Okay. Well, fine. If that's it, he says that the Pope authored the Magna Carta, right?
Thank him. It's right in it. Read it.
Fine. But the point is that I accept that for value. Okay. Okay. Now, but the point that I'm getting at is this: within a year, one of the two died, the king or the Pope. And I think it was like about 2-3 months later, the other one died. This created a power vacuum in both spheres. The new king was King Edward, and the new Pope, I can't remember who he was, but it created this power vacuum. You know, whenever you get a new leader in, he's got to establish his power base. He had enough power base to get to that position, but that doesn't mean he's going to be a success. I mean, we've had a lot of kings that only served 1 year, you know. And but you had this other power base called the noblemen, and they were still organized, and they didn't lose any time. First thing they did is they got King Edward to bless the Magna Carta, to reaffirm it, and they also got the new Pope to reaffirm it, and they had to because they didn't have the strength at that time. And then in succeeding kings, the Magna Carta was reaffirmed again. Is that correct? You know your history, right? Okay. So there you are. It was reestablished. Now, check this out. Confirmatio Cartarum. This was the second king, King Edward the First, and who followed King John. He signed the Confirmatio Cartarum, and here's the important point right here, starting with number 3. Okay. It says, Edward, by the grace of God, King of England, and so forth, he's delivering his message. This is a writing by the king. And he says, and that our justices, sheriffs, mayors, and other ministers, which under us have the laws of our land to guide, shall allow the said charters pleaded before them in judgment in all their points. That is, to wit, the great charter as the common law. Okay? So, if you are a defendant, you can demand that the Magna Carta be the common law. They can't force it on you. The common law is the common law. But if you demand that the Magna Carta be the common law, then the king's men, in other words, the judges and all those guys, sheriffs, whatever, they must accept that as the common law in writing. Okay? And this is an important thing. I got this out of a Bar Association book. Okay? That's where I found it. And you look at the Constitution of the United States and you look at the Constitution of California, they all support the common law. Well, what is the common law? This is what the common law is. The Confirmatio Cartarum, in other words, the confirming charter, says specifically that if you choose, then the Magna Carta is the common law. Now, there's a couple of neat things in the Magna Carta. Okay? Let me go down to the interpretation. It kind of distills it. Okay? Confirmatio Cartarum says the Magna Carta must be accepted as the common law by government. The Magna Carta is the supreme law. All other contrary law and judgments are void, and voluntary taxes cannot be made permanent. Where have you heard about that before? Okay. Now, I just picked out some highlights. There's more in those papers, but the issues that we're always dealing with, well, this is where, here's kind of like a quickie summary. Here I quote the Magna Carta, and then I give a brief, plain English explanation. So, Article 20 of the Magna Carta basically says the fine shall be proportional to the offense and shall only be imposed upon the testimony of non-government men. Okay?